presentation speech is from when I was on a mock trial team, and this is an opening statement where I was presenting part of my case to a mock trial courtroom. Your Honor, my fellow attorneys, my name is Joseph Grandy, and I am lead counsel representing the defendant in this proceeding, Mr. Kelly Roberts. To my right are my co-counselors, Ms. Grace Walker and Ms. Gloria Marsh. Your Honor, we are here today because the prosecution is attempting to disregard the Fourth Amendment of the Constitution by offering into evidence oxycodone pills that were obtained when police officer Bobby Flanagan performed an illegal search of the defendant's property. And throughout the course of this proceeding, the defense will prove that the oxycodone pills are, in fact, inadmissible. Today, you will hear the people say that the immediate recovery of the pills was made in accordance with both the emergency search doctrine and the extraneous circumstance doctrine. However, as the Court of Appeals ruled in People v. Jenkins, once a suspect is either handcuffed or secured, as the defendant was at the time of the search, the exigent circumstance no longer applies, as a suspect is no longer able to destroy, damage, or otherwise tamper with any evidence that might be seized. You'll also hear that the police people claim that the immediate need for a search was due to the fact that there was an impending rainstorm that occurred later that afternoon. However, as weather reports will support, 3.5 hours was more than enough time for a police officer to obtain a warrant to legally search a suspect's property when he had reasonable cause. The prosecution will also say that the search falls under the emergency search doctrine, since the yard where the pills was found happened to be next to a daycare center. However, Officer Flanagan did not deem it necessary to inform the daycare owner, Miss Samantha Doolittle, of the situation until after he had performed the search and seized the evidence against my client. The people will also be relying heavily upon the testimony of Mr. Leslie Mooney, a man who is simply unable to give an objective comment when it comes to talking about Kelly Roberts. Mr. Mooney's testimony is also irrelevant in this proceeding, since he did not have a first-hand report of the search or a conversation that happened between the defendant and Officer Flanagan inside the building. Also testifying for the people was Dr. Jordan Taylor, whose only relevant testimony in this case tells us what we already know, that oxycodone pills are highly addictive and soluble, and therefore will dissolve when exposed to water. In 1787, when the Founding Fathers were forming the Constitution, the Bill of Rights ended up becoming a crucial part of the Constitutional Convention. The Founding Fathers put the Bill of Rights into the Constitution because they knew that the people needed rights to protect them from an oppressive government. And if the pills that were seized as a result of Officer Flanagan's search are not suppressed, then what this court will do is destroy the fundamental rights upon which this country was formed and has lived under for 240 years. Thank you.